Something enormous has just landed on the Supreme Court's doorstep, and the timing could not be more critical. An emergency application has been filed asking the justices to immediately pause enforcement of federal restrictions on short-barreled rifles, a move that could ultimately unravel major portions of the National Firearms Act itself. What makes this moment explosive is not just what was filed, but when. Only weeks ago, the Supreme Court flatly refused to step in on earlier NFA challenges. No explanation, no dissents, just silence. For millions of gun owners, it felt like the court had slammed the door shut. And yet, here we are again. Before I explain why this new emergency request is fundamentally different, why it may succeed where others failed, and how a quiet legal shift may have changed everything, make sure you're subscribed. The court could act within days, and the ground beneath Second Amendment law is moving faster than it has since Bruen. What just died, and why it matters. To understand why this filing matters, you need to understand what collapsed just weeks ago. Two major cases were heading toward the Supreme Court: Rush v. United States and the Robinson Challenge. Both asked the court to intervene after lower courts, especially the Seventh Circuit, created total chaos. In Rush, the Seventh Circuit declared that short-barreled rifles are not even protected arms under the Second Amendment. Let that sink in. A rifle with a 16-inch barrel, constitutionally protected. A rifle with a 14.5-inch barrel, according to that court, not an arm at all. Second Amendment advocates expected the Supreme Court to shut that down instantly. Instead, SAT denied. No reasoning. No dissent from Justice Thomas. No signal at all. That denial left gun owners in Illinois, Indiana, and Wisconsin living under a precedent that says their firearms have zero constitutional protection. For many, it felt like betrayal. Why this new filing is different? While most people were still processing that loss, something unusual happened. This time, the challenge did not arrive as a standard SAT petition. It was filed directly on the Supreme Court's emergency docket. That distinction changes everything. The petitioners are not asking the court to review a past decision. They are asking for an immediate stay of enforcement, an order that would temporarily stop the federal government from enforcing NFA restrictions on short-barreled rifles while constitutional challenges continue. The legal standard here is completely different. To win emergency relief, petitioners must show a meaningful chance of success on the merits, immediate and irreparable harm, that fairness weighs in their favor, that granting relief serves the public interest. This is no longer about abstract legal theory. It's about harm happening right now.
The strategy that just backfired. Here's where things get controversial. When earlier NFA cases reached the Supreme Court, many expected the Department of Justice, under a pro-Second Amendment administration, to stand down. Instead, DOJ argued against taking the cases. They leaned on United States v. Miller and claimed the NFA's registration scheme remains lawful. Why? Legal insiders believe the DOJ was playing a strategic game. Focus on AR-15 bans first. Win for millions at once. Avoid niche weapons the media can demonize. But this emergency filing blows that strategy apart. Because something changed on January 1st, and it may have shattered the NFA's legal foundation. The $0 tax that changed everything. For the first time since 1934, the federal tax to make or transfer short-barreled rifles, short-barreled shotguns, suppressors, was reduced from $200 to $0. That wasn't just symbolic. It may be legally fatal. The National Firearms Act has always been justified as an exercise of Congress's taxing power. When the Supreme Court upheld the NFA in 1939, it did so only because Congress has broad authority to levy taxes. The court never analyzed the NFA as a gun regulation under the Second Amendment, because at the time, the Second Amendment wasn't even recognized as an individual right. So here's the problem. If the tax is zero, what is being taxed? A law that raises no revenue is not a tax. It is regulation, pure and simple. And regulation must survive Bruen. Why the NFA is suddenly vulnerable. The emergency petition argues that once the tax dropped to zero, the NFA lost its constitutional shield. No revenue, no tax justification, no fallback authority. What remains is a federal firearm registry, without historical precedent. Under Bruen, that means the government must prove a historical tradition of similar regulation from the founding era. They can't. There is no evidence of early American laws requiring registration, approval, or taxation of commonly owned rifles based on barrel length. Without the taxing power, the NFA must stand on Second Amendment grounds alone, and that is a fight the government has never won. Why the Supreme Court might act now? Normally, after denying cert on similar cases, the court would avoid the issue for years. This emergency filing arrived almost immediately after the denials. That's not an accident. It signals that petitioners believe they've introduced a brand new constitutional question the court has never addressed. Can Congress maintain a regulatory scheme after the constitutional basis for that scheme disappears? If the answer is no, the implications are enormous. This isn't just about short-barreled rifles. It's about suppressors, short-barreled shotguns, AOW classifications, the entire NFA framework, nationwide, the circuit chaos argument. The petition also highlights a growing crisis. Federal courts are openly contradicting each other. The Seventh Circuit says SBRs aren't protected at all. The Fifth Circuit strongly suggests they are. The Ninth Circuit depends on which panel you get. Your constitutional rights now depend on geography, under federal law. That alone is often enough to trigger Supreme Court intervention. What happens next? 3 outcomes. There are 3 realistic paths forward. 1 emergency stay granted. This would be seismic. Enforcement would halt nationwide. ATF prosecutions would stop. Registration requirements would freeze. It would signal that at least 5 justices believe the challengers are likely to win. 2 stay denied, cert granted. No immediate relief, but the court takes the case for full review next term. Still a major step forward. 3 total denial. Worst case scenario. But even then, the $0 tax challenges continue in lower courts, and the pressure doesn't stop. The clue everyone is missing. At the same time the court denied earlier NFA cases, it did not reject challenges to Illinois' AR-15 ban, California's magazine ban. Those cases were relisted. In Supreme Court language, relisting means active discussion. If the court rules AR-15s are protected in common use, the logic underpinning the Seventh Circuit's SBR ruling collapses instantly. This may be a long game, and the justices may be waiting for the cleanest possible vehicle. Final thoughts. By zeroing out the NFA tax, Congress may have accidentally removed the one thing holding the law together. The Supreme Court knows it, and the next few weeks could decide the future of federal gun regulation in America. When the court acts on this emergency request, pay attention to whether they request a government response, how fast the deadline is, whether any justice writes separately. Those signals will tell you everything. If this breakdown helped you cut through the noise, hit like, drop a comment, and stay subscribed. This may be the most important Second Amendment fight unfolding right now, and most people have no idea it's happening.